Hello, my viewers. I welcome you to another powerful presentation. Today, I'm going to talk to you about key clauses in real estate agreements. I remember how myself, Chukwuma Nkwoka, Esquire. Are you a property buyer? Are you a property investor? Are you a property developer? Are you a landlord? Or even a tenant? And you need to know the key clauses that every real estate agreement must have, whether it's a lease agreement, whether it's a contract of sale, whether it's a deed of assignment. You need to stay tuned to the end of this video to watch, to learn the key clauses in a lease agreement, key clauses in every real estate agreement. It's very important. If you're watching me for the first time, I want to encourage you to subscribe to my YouTube channel and click on the notification bell to get notification anytime I drop a video. And don't forget to like this video if whatever I'm doing here is pleasing to you. And also don't forget to share it. Key clauses in a real estate agreement. When entering into a real estate transaction, whether for buying, selling, leasing, or investing, the terms outlined in the agreement can make or break the deal. Take note of that. You must pay a crucial attention to that. These contracts form the legal foundation for the transaction and also define the rights and obligations of all parties involved. Understanding the key clauses in the real estate agreement is crucial to ensure transparency, minimize disputes, and as well as protecting your interests. Your interest is the most important thing. That's the title you actually have. And if you don't protect it, and if you don't pay attention to those clauses, especially the negative restrictive covenant on the agreement is going to affect you. So please take note of that. I want to walk you through all these key elements, key clauses you must see in a lease agreement, property transactions, any form of real estate agreements. Number one is identification of parties. This clause identifies the buyer, the seller, the landlord, tenant, mortgagor, mortgagee, transferor, transferee, as case may be in the agreement. Ensure that the names and the contact details are accurate, as any ambiguity can lead to the contract being unenforceable. If A is missing on the name of that person, note that it's a different identity. Just for instance, if your name is Benga, you put another thing there, maybe they resemble Benga, but it's not Benga, you are not the same person. So it's very important that you don't make mistakes. Identification of parties is very important so that they will not misconstrue a party to be somebody else. So it's very important that you do that. Then the next is a property description. A detailed description of the property, including its address, size, boundaries, and unique features, must be included. For leases, this may also outline specific part of the property being rented out. So please take note of that. We call it demised premises. Whatever you are giving out, you need to define it well so that you don't end up even giving your entire property out when you intend to give part of the property. For instance, you have a block of flats, four flats, and you don't define the property very well. You may end up leasing out the whole 4 flats to somebody instead of leasing out the 2-bedroom flats, which is 1 unit out of it. Very important. The third important key clauses that you must have in any agreement is purchase or lease price. The purchase price or lease price, depending on whether you are transferring by assignment or mortgage or whatever, or you are transferring by a lease. For sales agreement, this clause specifies the agreed upon price for the property. And also in a lease agreement, it outlines the rents already agreed by the parties. Very important that you know all these things. If you don't have all these things, you make mistakes. So please take note of that. Payment schedule is very important because that payment schedule will state the consideration of that transaction. And also any penalties for late payments. Clarity on this clause, avoid financial dispute for later or for future or whatever. Please take note of that. Don't make mistakes to engage. So the fourth one is payment term. That's the mode of payment. The payment structure, whether through installment, mortgage, or a lump sum, you must also ensure that it's well detailed. This clause also includes timeline for payment, escrow arrangement if it's involved, and the provision for default. Please note that you must specify the terms of payment, whether you are paying outrightly or whether it's on installment. You need to know that. Then the fifth key clauses in real estate agreements is closing detail. In purchase agreements, the closing date is very important. When the ownership of the property will be officially transferred, it's not something that must be ambiguous. It must be something that is well definite. You don't need to be guessing when the property is passed or not. This clause also outlines the process for delivering keys, finalizing payment, and transferring title documents. When the owner will give you the old documents and hand you over the key of everything, that's closing detail. They must know the exact date. They must know the time when this thing is set to pass. So please take note of that. Don't just make mistake without thinking that. Then the sixth clauses in a real estate agreement is contingencies. Contingent clause protects parties by allowing them to resist the agreement under specific conditions. So you need to know when some certain conditions will make you to resist the agreement. Common contingencies include securing finances, passing the property inspections, or resolving title defects. So these are the things you need to put there. Then 7, inspection and due diligence, very important. This clause gives the buyer or the tenant the right to inspect the property and ensure it meets their expectation, and you should specify the time frame. So please take note of that. You don't make that mistake. The next one is title and ownership. Ensuring a clear and undisputed ownership of the property is crucial. You don't need to be guessing who owns this property. Is it on this person? Is it on that? Is it on the name of? No. You need to be very clear about that. This clause guarantees the seller or the landlord, as the case may be, to hold the legal rights to transfer the property and protect the buyer or the tenant from future ownership. So please note that whenever you are dealing with a property, title is very important. Ownership. So you need to know what you have, because you may end up thinking that you are having an assignment without knowing that you are getting a sub-lease. Please, and you may think you are getting also assignment, you end up getting a lease. So please take note of that, very important. Next one is maintenance and repairs, mostly in the tenants or lease agreement. For any lease agreement, this clause must actually be there, and it defines the landlord or tenant's responsibility regarding the property maintenance and repairs. It also prevents conflict over who bears the cost for the wears and tears or damages in the property. So especially landlord's features and fittings, you need to know, and also tenant features and fittings, you need to know all these things and know who bears the burden of taking care of the expenses. So the next is termination clause. Every of these agreements is required to have termination clause, especially when it comes to lease agreement. The termination clause specifies how and where the agreement can be legally terminated. It also outlines the conditions like mutual agreement, breach of contract, and non-payment, ensuring a clear exit strategy. Very important. The next clause that is very important is dispute resolution. Some people don't put it in their agreements, but it is very important that you put that in your agreements. Dispute resolution. No agreement is immune to dispute. So anything can come up, either from part A or part B. This clause stipulates how conflict will be resolved, whether through mediation, arbitration, or litigation. It can save time and cost by preventing a prolonged legal battle. So please take note of that. Very important. And in conclusion, but before I conclude, if you are watching me for the first time, I want to encourage you to subscribe to my YouTube channel and also follow me on all my social media platforms, because I always drop a very exciting video, very enriching video that will educate and enlighten and open your eye to so many things that you don't actually know about real estate transactions, especially in Nigeria. So please, if you are watching for the first time, I want to encourage you to subscribe to my YouTube channel and click on the notification bell to get notification anytime I drop a video, and don't forget to like the video and also share it to your friend, family, and well-wishers, most especially those interested in real estate transactions. So I conclude that this way. A real estate agreement is a very complex document. It requires a careful attention to detail. By understanding and negotiating the key clauses, you can safeguard your rights and ensure smooth transaction. Always consult a qualified real estate lawyer to review the agreement before signing, as this thing will save you time and make you not to enter into trouble. Please don't forget to engage a property lawyer. If you don't have one, go to the internet and Google, check the platform on the internet and see whomever that pleases you. Thank you for watching. I want to see you in my next video. Bye for now.